If you're thinking about filing a wrongful termination claim or any kind of employment discrimination claim, there's a legal term you're going to hear early and often: prima facie. Sounds fancy, but it's actually a straightforward idea once you break it down. Prima facie is a Latin term that means at first glance or on its face. In the legal world, it means that based on the facts you present, your case appears valid, at least enough to move forward. Think of it like crossing the first checkpoint. You don't have to prove everything right away, but you do have to show enough to raise a serious legal question. If we were looking at a car accident at an intersection, claiming that the defendant ran the red light and hit your car is enough to move forward with a lawsuit. In other words, you have put forth a prima facie case. Now you have to prove it. In an employment law case, like wrongful termination, harassment, or discrimination, that means you need to provide basic facts that fit a legal pattern. These facts have to suggest that what happened to you could be illegal if proven true. First example, hostile work environment based on sex. If you're dealing with a hostile work environment claim based on sex or gender, here's what you generally have to show. You were treated unfairly because of your gender. That treatment wasn't just annoying, it was serious or happened frequently. It affected your ability to do your job or made work feel toxic. And a reasonable person in your shoes would feel that way. If you can show these basic elements, then you've likely met the prima facie standard for that type of case. Example number 2, disability discrimination. For a disability discrimination claim, the law asked, are you legally considered to have a disability? Could you do the core parts of your job either on your own or with reasonable help from your employer? And were you fired, demoted, or treated unfairly because of that disability? If you can show those 3 things, you've crossed that first legal hurdle, a prima facie case. Just remember, prima facie doesn't mean you've won. It just means you've shown enough for the case to move forward. The employer will then have a chance to explain their side. Maybe they'll argue the firing had nothing to do with discrimination, or that it tried to accommodate you. If you think you've been wrongfully terminated or discriminated against, it's important to understand whether your situation meets that legal threshold. We can help you figure that out. Book a consultation to talk to an employment attorney who can walk you through the specifics of your case. Or, if you're not ready for a call, check out our legal leverage courses to learn how to protect your rights. Visit spigellaw.com/community to join our free online community and take our courses today. You don't have to navigate this alone, but understanding terms like prima facie is a great first step towards standing up for your rights.